Florida divorce law and interpreting marital settlement agreements. Hello, my name is John P.L.L.C. I'm a trial lawyer with the P.L.L.C law firm in West Palm Beach, Florida. Our firm restricts its practice to litigation, trials, and appeals involving wills, trusts, estates, probates, guardianships, as well as related commercial and business litigation, and litigation involving life insurance contracts, as well as financial accounts, real estate, and homestead. So why am I speaking as a probate lawyer about marital settlement agreements? Well, I'm speaking about a marital settlement agreement because many times the worlds of probate law in Florida collide with Florida divorce law, or what we call Florida family law. Now, I'm not a Florida family law attorney. I don't handle divorces. I don't handle marital settlement agreements until somebody dies. When somebody has passed away and they're either in the middle of a divorce, you have a number of probate issues and estate issues that come up, particularly if somebody owes somebody money, and particularly if money was not distributed yet during the divorce. Your Florida probate litigation law firm is going to want to know whether the divorce proceeding actually had a judgment of divorce ruling that the parties are divorced, and they just haven't distributed the property or divvied up the property equitably yet, or whether the divorce proceeding never issued a judgment, in which case the parties died married to each other. Those are very, very important inheritance rights that the parties to that divorce are going to want to know. Remember, you're not divorced until a judge says you are divorced and issues an order or a judgment on the dissolution of the marriage. So if you die, even though you've filed for divorce and you folks aren't living together, if there's been no official divorce, the surviving spouse, the widow, has very valuable inheritance rights to the estate of the deceased spouse. By the same token, if you are divorced and the parties have executed a marital settlement agreement, or there's been an order or a judgment on property distribution, and the judgment from the divorce court requires one party to pay the other party money, or requires one party to do something like keep a life insurance contract in place, those rights can be exercised in the deceased person's estate. So if you're subject to a divorce, you have a marital settlement agreement or a judgment on property distribution, what happens when one of those parties passes away and they didn't live up to the marital settlement agreement in Florida, or they owe money, or they were supposed to do something under that divorce or property judgment and they didn't do it? Well, now the divorce world is colliding with the estate of the probate world in Florida. And you have to read the marital settlement agreement, and you have to read any divorce judgment that was entered. Now, a recent appellate court case in Florida talks about interpreting marital settlement agreements. A May 4th, 2016 case from the 4th District Court of Appeal. The 4th District Court of Appeal is Florida's 4th DCA. It's an appellate court for Broward County, Martin County, and Palm Beach. And they often issue appellate opinions on probate, estate, and trust matters, as well as divorce and family law matters in Florida. And they talk about the interpretation of a marital settlement agreement and what lawyers can call the rules of construction. How do you interpret the marital settlement agreement if a term is ambiguous or unambiguous, or it appears to be ambiguous? So if you're involved in estate litigation involving the interpretation of a marital settlement agreement, you might want to read the Feliciano case, F-E-L-I-C-I-A-N-O. May 4th, 2016, from the 4th District Court of Appeal. The case number is 4D14-3242. It talks about how we interpret contracts in Florida. It talks about how we interpret language in documents like contracts in Florida, whether a term is ambiguous or unambiguous, and more specifically about interpreting a marital settlement agreement. Marital settlement agreements, divorces, those matters are very important to our firm because we not only handle appellate law and appeals of such matters, but when a spouse to a marital settlement agreement or a pending divorce passes away, there are a number of inheritance and creditor rights that need to be exercised or at least understood in the probate or estate context. Ask any Florida probate litigation law firm and they'll tell you they've had more than one case involving divorced parties in a Florida estate. My name is John P.L.L.C. and this concludes my remarks about Florida probate law and marital settlement agreements.